excused to assume that laws are more dependable than policies due to their stricter formulation process. However, this in reality is a myth. In fact, false narratives can infiltrate the lawmaking process as well. For instance, consider the law that replaced jury unanimity with majority verdicts. This change was promoted under misleading claims, suggesting that criminals were boycotting trials and tampering with the juries. In reality, there was no evidence at all to support these claims. In fact, the evidence at the time suggested a different picture, which was totally overlooked. Roy Jenkins, the Home Secretary at the time, offered a detailed analysis centered on the Central Criminal Court, which at the time handled 5% of all trials on indictment. He noted that there were 49 cases of jury disagreements that year in that court. Jenkins argued that these figures supported the introduction of majority verdicts to save the significant time and efforts required for retrials. However, Jenkins overlooked a critical point. Of the 49 cases, which then resulted in retrials, 25 resulted in conviction after a retrial, and 14 led to acquittal, while 9 ended in a second disagreement with no further action. One case was not retried. This meant that a substantial number, i.e. 23 cases out of the 49, led to either acquittals or no further action upon retrial. Under the majority verdict system, these individuals would have been convicted instead. A striking example is the case of Andrew Markinson, who was convicted by a 10-2 majority. Had unanimity been required, he might not have been convicted at all. His case would have gone to retrial and possibly resulted in an acquittal or further disagreement and therefore no further action. This highlights the profound risks and injustices that arise when laws are enacted based on false narratives rather than a genuine reliance on data analyzed as evidence for or against their implementation.